participation exercise at the constituency level gave 1 day notice on 4th of October 2024, the same date as the court ruling. Let me clarify here that the participation exercise was supposed to be on 4th of October 2024 for 1 day. But the ruling of Justice Moho, your brother, extended the participation for another 1 more day. Now that advertisement or publication also came in the same day when these exercises were supposed to finish. Now, what would happen that to the common mwananchi? Of course, confusion. Similarly, the orders which were given said that now the exercise should move from the county to the constituencies. The honor, what we noticed here is that in the constituencies, just talked about constituencies, never gave a specific place, address where this exercise is supposed to take place. It's our submission that such an important exercise to remove the deputy president from office, who was elected by the majority of Kenyan in each gazetted polling station in the country, required a similar methodology and the participation to remove him from office. And certainly, the purported NGCDF officers advertised without prescribed venue address did not meet Justice Mwongo's court order to provide venues close to the people. In any case, the only venue close to the people is polling stations. The honor here, as I said earlier, even with the orders, needed to have the exercise done at the constituency level. And the assumption here is that each constituency has these officers. But then what's the distance between where those officers are? They were not prescribed for somebody who's at the end of the corner of that constituency. By using highly legalistic language in the notices of public participation and in the circulated public view template, the assembly created a barrier to entry for the average mwananchi, reducing a constitutional right to a binary of support or oppose vote. The report indicates that primary information was hosted on the national television broadcast KBC, print media, the parliamentary website, and social media, which was technologically biased and excluded vulnerable groups. In the BPI case, the court stated that relying heavily on technology ignores the reality that only small fraction of Kenyan as reliable internet access, and that technology has not been dispersed equitably to all Kenyans. Similarly, despite the Persons with Disability Act of 2025 requiring free sign language and braille in public forums, the Gachagua impeachment exercise failed to provide even the most basic reasonable accommodation for these 5% of the population with special needs regarding the exercise, which was unconstitutional as per Article 54. The report does not demonstrate that the public was provided with copies of the special motion, including the grounds in English, Kiswahili, prayer, and other communication channels and technology accessible to persons with disability, such as the Kenya Sign Language. In Turkana, as an example, as well as other marginalized regions where the report shows zero response via hand delivery and email, The report does not demonstrate whether it provided any mobile registration units or outreach as required by the PPI case to ensure nomadic communities were also involved. The notice, as I think it's been mentioned again, presents a one-sided script. It presents the public with the grounds for impeachment without the first petitioner's response. This was not a search for truth. It was an exercise in prejudice. By suppressing the petitioner's side of the story, the state violated its rights to fair hearing and public's right to make an informed decision under Article 47 and 50, respectively. And this is found in our submissions, page 48 and paragraph 107. One submit that since the reasonableness of the notice is to be determined on case-by-case basis, the adequacy of notice in the present impeachment process can be tested against the scale of electoral mandate it seeks to overturn. This is found also in the submissions, page 47 and paragraph 104. In 2022 Kenyan general election, the presidential mandate was exercised by approximately 14.3 million voters out of about 22.1 million registered voters nationwide, reflecting a wide democratic participation. Out of those who cast valid votes, roughly 7.1 million supported the ticket of William Ruto and Rigathi Gachagua, thereby conferring upon them the constitutional mandate to govern. This mandate was granted by voters decentralized across the 290 constituencies and dispersed across at least 24 counties in accordance with the constitutional requirements. That is also in our submission, page 4 and paragraph 2. Therefore, by contrast, a constitutionality-compliant impeachment process ought to demonstrate that the public participation notices reached a substantial and representative proportion of that electorate. In the present case, the notice issued reached only a negligible fraction of the electorate, attributed to short times, limited publication channels, and accessibility to forums, which processes clearly falls short of the constitutional standards. And of course, my learned friend Tom Macharia has mentioned that this is evidenced by the alleged 200,000 plus viewers in the National Assembly report, which constitutes about 0.14% of the vote that mandated their win. Your Honor, statistically, of course, it sums up to a 0%. If it was a medical test, it will show negative results. There were only 11 memoranda that were presented to Parliament. Your Honor, and again, this I think has been said, I won't repeat it. This begs the question whether the National Assembly is suggesting that the sovereign will of 22.1 million registered voters in the nation is carried in the pockets of the 200 plus individuals who allegedly participated in the exercise. Your Honor, as you retire, you will find that the National Assembly's failure to issue reasonable notices contributed to the dismal performances in the public participation exercise, which cannot be taken to proportionately hold the views of the majority who voted the president and deputy president into office. I also dare to say that the mode of the instruments that were used to collect information, the template instruments used in the public participation exercise lacked clarity, thus ambiguous, contrary to the Supreme Court guidelines. The viewers template instruments to collect data from the public participation exercise failed verification and identifiability test. And of course, we've mentioned that initially, which I think is a point note, they were the first templates that did not have provision for identification. Then later, they were replaced. But we don't know the forms that were already in the public, what happened with them? Did they collect data? Is that data part of what was collected and reviewed? That information we don't know. Parliament equally did not state clearly how they were verifying the information they got from the public. Finally, let me just finish now. I wish, just to draw to your attention, this was your ruling here in this court, in the same case of Gachagua. Gachagua and 40 others, versus the Speaker of the National Assembly, and 15 others. 224 KEH 13473. This is what you stated. The impeachment case exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue. One that has significant implication for the doctrine of separation of power. Your Honors, the eyes of the nation are indeed upon this court. We echo your sentiments in paragraph 101, which reminds us that the people of Kenya fought for a transition away from marginalized judiciary. They envisioned a new order where government excesses are checked and where no harm of government operated beyond scrutiny. If the standard of public participation is allowed to fall as low as it did in this case, characterized by unverified templates, digital exclusion, and binary trap, then the Constitution promise of the will of the people becomes a dead letter. Thank you, Your Honors, for the opportunity to address you.
Thank you. Good afternoon, my lords and my lady. I rise to highlight issue for determination E.
Your name, please.
My name is Echesa Willis. My lords and my lady, I do rise to address and highlight submissions with regard to the issue for determination number E, that is at page 11 of the issues for determination, as have been crystallized by the first petitioner. My lords and my lady, the substance of issue number E is to be found at page 51 of the first petitioner's submissions. And my lords, taking cue from the presiding judge's direction, I will not repeat what my learned colleague, Mr. Tom Macharia, has addressed the court with respect to Article 47 of the Constitution, as well as Article 50, sub-Article 1, with regard to the right to fair hearing as well as fair administrative action. My lord, I will, for purposes of guiding the court in appreciation of this issue for determination, I will draw the court's attention to the further amended petition, specifically averments contained at paragraph 97, as well as paragraph 106. My lord, that is the foundational essence of the issue for determination that I shall be highlighting. My lord, further to that, I do redirect the court's attention to the affidavit in support of the petition sworn by His Excellency Rigathi Gachagua. My lord, this is sworn on the 18th of October 2024. And my lords and my ladies, specific to the issue that I'm highlighting on, issue number E, my lords, I do direct the court's attention to the deposition made at paragraph 8H, that is at, it's not paginated. The next factual preposition, my lord, is the deposition made at paragraph 22. And lastly, I shall make reference to the supplementary affidavit of His Excellency Gachagua, sworn on the 27th of October 2024, specifically at paragraph 6. My lords and my lady, against the backdrop of what my learned colleagues that have made submissions ahead on the provisions of Article 47 as well as Article 50 sub-Article 1 that embody the requirement of fairness in decision-making before decision-making bodies, as has been submitted, my lord, the role of the Senate in this particular proceeding leading to the impugned impeachment, it has been submitted ably by my learned colleague, Mr. Macharia, that this was a quasi-judicial process. My lord, submissions have been made with reference to, and in this particular, at this particular juncture, I do refer to the exhibit RG1, that is, my lords, the exhibit to the supporting affidavit that annexes exhibit number 1 that starts at page 566 through to 566 through to 583, my learned colleagues did indicate that there were pre-coalition agreements, and my lord, I would urge this court to take note of the specific provisions in these coalition agreements, specifically at page 588, which is specific with regard to the reservation of the position of the Speaker of the Senate. My lord, I refer to, this is the agreement between the Kenya Kwanza Alliance Coalition and the Pamoja Africa Alliance Party. Next, my lord, is page 567 that exhibits the coalition agreement between the United Democratic Alliance and the Amani National Congress Party and Ford Kenya Party. I will redirect the court's attentions to page 578. This is at Article 21, subparagraph L and N. My lords and my lady, what those annexures, the purpose of those annexures is to amplify the fact that the speakers of both the National Assembly as well as the Senate were direct beneficiaries to the pre-coalition agreements that were in place, and that which had been submitted by the first petitioner first before the National Assembly on the 8th of October 2024 in response and in his defense with respect to ground one that raised the charge on the so-called shareholding issue. My lords and my lady, the point to underscore in regard to those coalition agreements is that as early as the 8th of October 2024, when the first petitioner tendered his defense to the grounds that were purportedly moved by the National Assembly, it was clear that part of the evidence that the first petitioner was to present implicated or showed the involvement and the interest of the Speaker of the National Assembly. However, my lords and my lady, the Speaker of the National Assembly did not deem it fit to recuse himself, noting that the issue of his interest would play out in the defense of His Excellency Rigathi Gachagua. Further to this, when the motion was or reasonably believed that it was seen by the then Speaker of the National Assembly, the Speaker of the Senate, that the coalition agreement that begot him his speakership was also in question, as it had been brought up by the first petitioner in his defense of ground one that had been then passed by the National Assembly. In summing up, my lords and my lady, Impartiality is the essence, is essential for decision making, and as my learned colleagues have indicated, the process demonstrated what my senior counsel, Mr. Ongoya, has referred to as malicious compliance, breakneck speed with regard to the moving of the motion, as well as the directions, as well as interpretation that was given to various provisions of the Constitution by both the Speaker of the National Assembly and that of the Senate. In summing up, my Lord, the petitioner has, in his bundle of digest and bundle of authorities, made reference to the decision of Njiru and 11 others versus Kenya Kwanza Coalition and 18 others, which my learned colleague, Mr. Macharia, made reference to. I do urge your lordships and your ladyship, when this court retires to deliberate on the ruling, on the judgment, to be guided by the 3 judges in holding number 20 and 21 of that decision. I do submit that those 2 holdings are on all fours on the submission in relation to Article E before this court. So the issue for determination at E before the court. And in closing, my Lord, with reference to the issue for determination whether or not the speakers of both the National Assembly and that of the Senate were neutral, I do invite this court to do what the court recommended in the decision of Philip K. Tunoi and another versus the Judicial Service Commission and another, it's a 2016 decision, where the court held that in determining the existence or otherwise of bias, the test to be applied is that of a fair-minded and informed observer who will adopt a balanced approach and will neither be complacent nor be unduly sensitive or suspicious in determining whether or not there is a real possibility of bias. I do invite this court to apply that test. And my lords and your ladyship, based on what has been presented by the petitioner, we do submit and urge the court to find issue number E in the affirmative. I'm much obliged.
Thank you.
May it please your lordships and your ladyship, my name is Faith Waigwa for the first petitioner. My lord, I shall be addressing you on issue G. Issue G is the second last issue framed by the first petitioner and speaks to the invalidity of National Assembly Standing Order number 64. To start off, my lord, at paragraph 147 of the first petitioner's submissions, dated 7th October 2025, we did highlight the issue as National Assembly Order number 46 as opposed to 64. So we wish to correct that now. The body of the paragraph speaks to the correct provision, which is 64. It's just the heading that there was a spelling mistake. My lord, the question we pose on this issue is, can an internal procedure of Parliament Internal Procedure Rule of Parliament, namely the National Assembly Standing Order 64, constitutionally compress an impeachment process of the magnitude where a deputy president is being removed into timelines so short that they effectively extinguish the constitutional duty to facilitate meaningful public participation. My learned colleagues and seniors have ably submitted on the issue of public participation, but I'll try as much as possible not to repeat, though, my lords, you'll allow me to demonstrate why this particular provision of the standing order goes against the constitution provisions of public participation. And to that extent, we will be answering our question in the negative. And towards the end, we will invite you, my lords and my lady, to find that that standing order 64, 2 in specific, and to the extent relevant, 64(6) are unconstitutional, null and void, to the extent that they impose timelines whose purpose and effect is to undermine Article 10 of the national values, Article 118 on participation by the public, Article 1 on sovereignty, Article 2 and Article 124 of the Constitution. My lord, this is not an attack on parliamentary autonomy. It is a defense of constitutional supremacy, and we proceed to demonstrate as follows. A procedural rule that makes meaningful public participation impossible is itself unconstitutional, however neatly drafted. The vice in Standing Order 64 is not merely that it provides timelines. The problem is that those timelines are constitutionally disabling. And I will demonstrate what Standing Order 64 provides. It requires, 1, the National Assembly's Speaker to dispose of an impeachment motion within 3 days of its notification. Thereafter, it provides the disposal of the impeachment motion by the National Assembly within a period of only 7 days. We have 339 members of the National Assembly who are supposed to dispose of the impeachment motion within 7 days. And lastly, it provides for transmission of the resolution of the National Assembly once they've passed the motion to the Senate within 2 days. The real vice falls under under Standing Order 64-2, where the National Assembly has only 7 days within which to dispose of the impeachment motion. This standing order compresses a matter involving reversal of several sovereign electoral choice into 12 days, thereby making meaningful public participation illusory. And where participation becomes illusory, Articles 10 on participation of the people being a national value and principle of governance is affected. And Article 118 on public access and participation is also affected. Article 2, my lord, of the Constitution is supreme. Anything inconsistent with it is void. The standing orders themselves derive their authority under Article 124 of the Constitution, and therefore, they do not sit above the Constitution. and cannot cut down constitutional obligations. The Supreme Court in Mate and another versus Wambora and another, 2017, the court held as follows. Courts have jurisdiction to interrogate even parliamentary standing orders for constitutional compliance. So this principle, my lords and my lady, answers any argument by the respondents of non-justiciability. This honorable court is being invited to supervise parliamentary politics. It is being invited to perform its constitutional duty of reviewing constitutionality. My lords and my lady, constitutionality is judged not only by text, but by purpose and effect. So we look at what is the purpose of Standing Order number 64-2. Its purpose is to force expedited disposal of impeachment motions. But what is its effect? In reverse, to restrict Parliament ability to facilitate meaningful public participation in the impeachment proceedings. With this, Standing Order number 64-2 has a purpose and effect that undermines constitutional rights and national values and principles of governance, and therefore should be found to be invalid. The petitioner specifically pleads this at paragraph 98 of its further amended petition. And that is the vice before this honorable court. My lords and my lady, impeachment is not ordinary parliament business, and that has been admitted by the respondents when they say impeachment is not necessarily a legislative process. It seeks removal of a directly elected constitutional office holder, and in practical terms, revisits the sovereign will expressed at the ballot. It is that serious. Such a process demands heightened constitutional safeguards, not reduced ones, like we have seen in Standing Order number 64. Yet Standing Order 64 does exactly the opposite, my lord. That inversion should then be found to be unconstitutional. My lord, I won't repeat what has been submitted before you on public participation. However, you've heard clearly that public participation conducted on the 4th and 5th of October 2024 did not meet the threshold of the principles laid out in the BAT case. This is the British American Tobacco Kenya PLC versus Cabinet Secretary of the Ministry of Health. And allow me to just point out what violations were made. And had we had more time, had the National Assembly provided for more time in its standing orders, perhaps they would have averted these particular violations. One, Mr. Swanya indicated of the no reasonable notice was issued. A notice of extension of public participation was issued on the 5th of October 2024, which was the last day and D-Day for public participation. There was no reasonable notice whatsoever. There was no informed participation. The people of Kenya were provided with information that was minus the defense by the first petitioner, where they had one-sided story for them to consider whether to impeach or not to impeach the second deputy president. There was no balanced influence. We've heard clearly that at Bomas of Kenya, participants were actually told that the forum was for invited members of the Orange Democratic Movement. That's ODM party. Members of parliament swayed participants during this engagement. We've heard that. Therefore, the process was partisan and violates the requirement of balanced influence. We've also heard of the no integrity or transparency because forms were unverified and cannot still be verified to date. No serial numbers on those forms that were used for public participation. No methodology was disclosed. And statistical anomalies such as 162.78% support in Keyo South was reported. Clearly, we will all agree that this speaks to constitutional fraud. Again, my Lord, I reiterate, if the National Assembly had more than the 7 days required to dispose of this notice, this motion, impeachment motion, then perhaps these violations would have been averted. The respondents may argue timelines alone do not invalidate a process. However, our response would be not every short timeline is unconstitutional. So we might agree. But a timeline becomes unconstitutional where it makes constitutional compliance impossible. And that is the case with Standing Order number 64. Why do we say the timelines there are unreasonable? First, it allows no genuine civic education before participation because the public participation was conducted by National Assembly. Second, it allows no adequate dissemination of relevant information across 290 counties. Third, it allows no serious compilation, analysis, and debate on public views. And violates procedural fairness. The fact that the defense of the first petitioner was never disseminated to the public to make an informed decision, that process was unfair. My Lord, allow me to compare these timelines with those of the presidential election petition. We all know and understand that a presidential election petition is filed by a person who has arguably lost a presidential election. This petition is supposed to be heard and determined within 14 days by a 7-judge bench. In contrast, when removing the same president who's been confirmed perhaps in the presidential petition, the National Assembly allocates itself only 7 days to remove a president or a deputy president who was validly elected using universal suffrage, and the people sitting to remove the president or the deputy president are 349 members of the National Assembly against only 7 judges at the Supreme Court when hearing and determining an election petition. My lords, there is a problem. That removal has to be extremely fast, but confirming can have more time. Confirming a president can have more time, but the removal of such a president or deputy president must be extremely fast. My lords and my lady, I'll draw some comparatives from parliamentary systems of government, which my learned colleague, Ochiel Dudley, was able to bring to your attention. We did the research with him. In Nigeria, the timelines are 4 to 5 months. 4 to 5 months for the entire process. In Kenya, the process is around 2 weeks to 4 weeks maximum. In South Korea, Constitutional Court is given up to 180 days to render its determination. In the US, my lords and my lady, we will be surprised that there are no rigid timetable. But historically, what has been happening is around 2 months or more. And the reason is that the flexibility exists because of the gravity of such matters that demand deliberation. So you will find from the countries we've drawn your attention to is that they are more of an investigative process as opposed to a mob justice process that took place in our country at the National Assembly. Why are we comparing this? This comparative material is not cited to import foreign constitutions. It is cited to illuminate a constitutional principle. Basically, Kenya is an outlier when it comes to timelines for removal of its president or its deputy president. Where removal overturns a popular mandate, constitutional democracies favor deliberation, investigation, and participatory legitimacy, not speed. I repeat, my lords, not speed. So the Kenya's National Assembly Standing Order 64 runs opposite to this democratic pattern. Article 124 creates standing orders as subordinate procedural instruments. Being subordinate procedural instruments, they therefore cannot dilute Article 10 on participation of the people as a national value and principle of governance. They cannot dilute Article 118 on public access and participation. They cannot dilute Article 1 on sovereignty of the people. They cannot dilute Article 47 on fairness in administrative actions and quasi-judicial outcomes and decision. My lord, they cannot dilute Article 50 on fair hearing and Article 2 on the supremacy of the Constitution. As I conclude, my lord, constitutional obligations are not optional where timelines are tight. If timelines make it impossible, then those timelines must yield, not the Constitution to yield. My lords and my lady, would want you to look at expediting the process as a value, but participation of the people should be looked at as a constitutional command. When they conflict, then the Constitution prevails. We respectfully invite this Honorable Court to hold that the National Assembly Standing Order 64-2, and to the extent inconsistent Standing Order 64-6, why we say so, my lady and my lords, is because the 2-day timelines is provided in the Constitution. That is what has been captured under Standing Order 64-6. Violate Articles 10, 118, 1, 2, and 124. If you find favor with our prayer, then Standing Order 64, 2 and 6 should then be found to be invalid for being unconstitutional. My lady and my lords, as you retire to write your judgment, we need to answer to this question. We kindly request that you address yourselves to, can sovereign will expressed through election be reversed through a process too hurried, like that at the National Assembly, having been given 7 days, for the people to meaningfully participate in it? We look forward to a respectful answer of no. And for these reasons, we respectfully urge this honorable court to declare the Standing Order 64-2 and 64-6 as unconstitutional, null and void, to the extent they impose timelines whose purpose and effect is to undermine the articles that are mentioned, 10, 118, 1, 2, and 124 of the Constitution. I so respectfully submit. Thank you.
Thank you.
My Lord and my lady, my name is Njomo John, appearing for the first petition with my colleagues, and I'll pick up from where my learned colleague Faith Waigo has left. I rise to briefly submit on the reliefs that the first petitioner is seeking before you. I know counsel who has submitted before me have mentioned variously part of what I'm submitting on, and that is the reason why I will not take long. My Lord, when this court delivered its ruling on the 31st of October last year, I want to refer to paragraph 158, being the background under which the first petitioner is before you. He's literally in court today. Your Honor, there were worries as to what the court would do in the outcome of an impeachment and election or nomination of a deputy president in replacement of the second deputy president. And this is what the court said. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience. Moreover, the Honorable Attorney General, through Senior Counsel Guido Muigai, has given an undertaking to comply fully with any orders that this court, any orders issued by this court in this matter. So that when we come before you, this court has an open page. All the reliefs that the petitioner is seeking are grantable by the court, because even Professor Guido Muigai, it's on record that he has given an undertaking that there will be full compliance. So that, my Lord, the reliefs that the first petitioner is seeking are captured at paragraph 148 all through to paragraph 148 of the submissions. This is appearing at page 61 of the submissions by the first petitioner.
Page.
Page 61. That is prayer number H. What are the appropriate reliefs? Starting from page, paragraph 148, running all the way to paragraph 152. And Your Honor, there has been various mentions of the issue of public participation. I want to address the prayer relief number 1, that is A declaration that the respondents have contravened the provisions of Article 10 and Article 118(1) of the Constitution by initiating a process leading to the removal of office by impeachment against the petitioner. My Lord, relevant to that particular prayer is the definition of what Parliament is at Article 93 of the Constitution. And this is what it says. There is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. And very briefly, my Lord, we have been told there was some semblance of public participation conducted by the National Assembly. But on record, nothing has been demonstrated, or rather, the respondents, especially the Senate, has not given any indication that there was any semblance of public participation. The reason why I'm saying this is because Parliament is both the National Assembly and the Senate. Even if there was some public participation initiated by the National Assembly, there was none whatsoever that was initiated by the Senate. This is the reason why we are saying that there is violation of Article 118(1) of the Constitution, because the Constitution requires that Parliament shall conduct business in an open manner, and in its sitting and those of its committees shall be open to the public. It goes further to say that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So that then the question is, what happens when the Senate conducts its business without involving public participation, without invoking public participation? The answer can only be that there is a clear violation of Article 118(1) of the Constitution, and we pray that then the court finds that in favor of the petitioner. My lords and my lady, we have gone to pray for a declaration under B. I don't have to read the whole of it, but it has been explained by counsel that some of the charges that were confirmed against the first petitioner, there was multiplicity and duplicity of charges. That you have allegations and particulars being referred to in support of a given allegation. So that then what we pray under a declaration that we are seeking under B, motion lacks the particularization and specificity required by Article 145(1) of the Constitution. This is important because it was submitted by Senior Counsel Ongoya, and he explained in detail how the charges 3, 4, and 5, particulars that were relied upon were in particulars or the charges in A and B, charge 1 and B, so that there were no particulars in support of those other allegations. The next prayer that the petitioner is seeking is as regards the inconsistent and violation of the Constitution under B, a declaration that the resolution passed on the 8th of October 2024 by the National Assembly to impeach the petitioner pursuant to the provisions of Article 145 and 150, and the communication dated 8th October 2024 sent by the Clerk of the National Assembly to the Senate titled that are both founded on a process that is inconsistent and in violation of the Constitution of Kenya. The reason why this prayer is being sought, my lords and my lady, is for the reason that there were many inadequacies resulting to the impeachment process, both at the National Assembly and the Senate. So that the culmination of it is that the process was a sham, and whatever that resulted from that particular process cannot sustain the impeachment process, so that we pray that the court can grant prayer number C as sought in the amended petition. My Lord, we also sought a declaration that for the purpose of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. My Lord, the background on this is that the election of the Deputy President and the President takes place at the polling station. Council who has submitted before me have explained to my lords that the initial notice that was given was that public participation was to be undertaken at the county level. Subsequent communication was that there will be public participation at the constituency level, without an indication as to where, the venue, and more details to allow members of the public to meaningfully participate in public participation so that they can give their views. So that without a clear communication that public participation was to take place in all the 290 electoral constituencies and the 1,450 electoral wards, then that process cannot be said to have met the constitutional threshold on meaningful public participation. It is for that reason then that my lords, we pray that you can find in favor of the first petitioner the declaration that is seeking under D. The subsequent declaration is on the timeline that was given, a declaration that the 12-week period provided under standing order 64.2 and 64.6 of the standing orders of the National Assembly is grossly insufficient. My Lord, I will not repeat that because Council Faith Waigua has elaborated on the inadequacies and the prayer to have the same declared unconstitutional. Subsequent to that, my Lord, we have prayer number F. Most of those others I'll consolidate. A declaration that the proceeding before the whole House plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited to time-bound 10 days. This is, my Lord, what Ochiel Dudley explained, that the 10 days that the Senate imposed on itself was not, did not have any legal basis, so that it was not justifiable for the Senate to impose itself on a 10-day period to conclude the business in a very rushed manner. As it was indicated by the Speaker of the Senate, they wanted to do that with military precision so that they could attain a premeditated outcome in our submission. My Lord, prayer number G is a declaration that the petitioner's right for fair administrative action under Article 47, a right to fair hearing under Article 50 of the Constitution were violated. My Lord, it has been explained in detail how the first petitioner was denied a fair hearing, so that even at a point when he fell ill, it was communicated to the Senate, and Senior Counsel Paul Muite explained to the Senate the circumstances under which he was not able to proceed with the hearing before the Senate. The Senate proceeded, regardless of that particular communication, to proceed with the impeachment process. So that is a very clear indication that the process was not fair, and the rights of His Excellency regarding Gachagua under Article 50 were violated to the fullest. My Lord, declaration number H that you're seeking is that the National Assembly and the Senate, in their evaluation of the impeachment proceeding before them, failed to properly assess each of the specified ground and determine if they collectively and individually constituted gross violation of the Constitution. My Lord, it has been explained to you again that even where a provision of the law has been declared unconstitutional, the National Assembly and the Senate still proceeded to find and uphold those particular allegations. The alikees have been explained, and the court has been taken through the process leading to the invalidation and declaration of the unconstitutional provision under that particular act. But nevertheless, the National Assembly did not consider it necessary to find that some of those allegations were even illegal, were unfounded, and could not stand the test of law. Next to that is an order that this court quashes several documents and communication. I will not read each and every order, but we have sought orders of certiorari to remove and quash the communication of 8th of October 2024, 17th of October 2024, resolving to remove the office of, from office by impeachment His Excellency Rigathi Gachagua as the Deputy President of the Republic of Kenya. The reason for this, my Lord, is, as explained before, that there were legal illegalities that were committed along the way, and these particular notices of 8th of October and 17th of October were the culmination of those particular illegal proceedings, so that the only justifiable cause that the court can give is to quash the notices of 8th of October and 17th of October 2024, respectively. Subsequent to that, there is also a request or a prayer that the notice by the Senate of 17th of October be quashed. This is the notice communicating the impeachment of His Excellency Rigathi Gachagua to the National Assembly. My Lord, we have then all the other prayers that we have sought. And my Lord, by the time someone is being elected to the office of the Deputy President or any other office, the expectations that come with it. We have given an authority that this court can award damages where there are violations of the Constitution. This is the case of Imanyara versus Republic, where the court held that where there are violations of the Constitution, and this is at paragraph 151 of our submissions. My Lord, you'll have a chance to look at it. The case of Imanyara and two others versus the AG, 2016 Kenya law reports, that where the court said that award of damages for constitutional violation of an individual's right by state or government are reliefs under public law remedies within the discretion of the court. So that at paragraph O of our prayers, the first petitioner has come before you and is praying for general damages, punitive and aggravated damages. These are not far-fetched because the court has previously found that they are awardable by the court, because if we have demonstrated to the court that his rights were violated, then the court can award damages as prayed under paragraph 01 of our submissions. My Lord, we have also explained in detail that he was earning a salary that maybe I don't have to give a figure because there's a lot of calculations, mathematical calculations, but you will have a look at paragraph O, where we have listed the benefits that the Deputy President was earning, what he was entitled to, and what his salary could have been if he worked for the 5 years that the Kenyan people had given him a mandate. So that we have therefore calculated those particular salary expectations and benefits that he was entitled to under the law. And we pray that the court can allow and award those particular prayers as sought. My Lord, the office of the Deputy President attracts some benefits, again, other than the salaries, which we have enumerated under paragraph P, because there are quite a number, including quite a number of issues, cleaners, gardeners, and all that. I believe that my Lords will have a chance to look at those particular prayers and the allowances that he could have been entitled to, could he have served his full 5-year term. We do have the play that the court will allow the prayers as sought, and I believe you'll have a chance to have a look at all of them in detail, one by one, in awarding and agreeing to allow the petition as prayed. I think, Mr. Mashari, you have a word to mention about it.
I just wanted to remind my colleague that he needed to emphasize that most fundamental matter called costs. We need costs on behalf of the Deputy President for all these bad things that have been done to him and to us. Thank you very much, my lords.
Well, that concludes the highlighting on behalf of the first petitioner. We thank you.
Thank you. I see Dr. Gada standing up.
Yes, Your Lordship.
You said you wanted 2 hours, huh?
No, 2 hours. We will be done in an hour less. Myself and my brother Sakimba.
I'm also present on behalf of the second petitioner. So I don't know if I will be able to address today or the other day. Oh, my name is Teresia Wanjiru Kimoto of Tess Kimoto and Company Advocates Kerugoya.
Yes, my lords, if I may, just for a minute.
Yes.
I'm not objecting to Tess. My lord, in terms of equality of arms, I am concerned that the petitioners, having had 5 hours, and the other parties having the possibility of attacking another 1 hour or 2 hours, would then mean the respondent then would have, in terms of equality of arms, we then need the same amount of time in responding. And you had given 6 hours previously. So perhaps I suggest that Evans Ogada, the professor, together with the other petitioners, then share the 1 hour so that we are equal, so that we don't go outside the 6 hours. Tess can take 20 minutes so that we...
Why me 20
Well,
minutes?
I think my learned friend, Professor Tom Ojienda, is being anticipatory. Let him wait and see perhaps how long we take. Then he can say at that time how much time he wants, rather than trying to, put the coat in some straitjacket. We are very grateful, those appearing for the first respondent, but I do plead that the other counsel appearing for the other petitioners have their day in court.
We are in court.
Yes.
We are in court. They are having their day.
They have their day.
Yes.
They have their day in court.
Yes.
Because what this honorable court will ultimately say, either way, is going to apply in future.
I think the only issue we need to address is how much time do we give them? And I think we should appreciate that we don't have all the time. So let us plan to share maximum of 1.5 hours.
Your Lordship, I'm sorry, but I'm constrained to object to that approach. When we had the hearing for the conservatory orders, we restrained ourselves and took our and allowed the court to limit our time. But I think for the petition, let us have sufficient time to ventilate on all the issues. We shall take the least amount of time possible. But if you say 1.5 hours, and Dr. Ogada is coming up, I do not know how much time you will have to for the rest of us.
I think we are wasting time. Let's proceed. We'll see how far we'll go.
Good afternoon, Your Lordship, Your Ladyship. I appear alongside my brother, Mr. Sakimpa. We appear on behalf of the 4th to the 8th petitioners. Ab initio, we will be relying on the following documents. We will be relying on the petition dated 18th October 2024, the affidavits in support sworn on 18th October, the written submissions dated 16th January 2026, the list and bundle of authorities dated 16th January 2026, the further list of authorities that dated 25th April 2026. All power has a limit. all power has a limit. Certain values in the Constitution have been designated as foundational to our democracy. This in turn means that as pillar stones of this democracy, they must be observed scrupulously. If these values are not observed and their precepts are not carried out conscientiously, we have a recipe for constitutional crisis of great magnitude. In a state predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. That is a paragraph from Nyathi versus member of the Executive Council for the Department of Health, Gauteng, and another 2008, Madala J at paragraph 80. It's in our list of authorities supplied, dated 25th of April 2026. My good friend, Elisha Ongoya, wandered in the morning, and I joined him in the wandering. Which way, Kenya? What is the state of our morality in terms of our constitution? We have provided a case, and that case will form my next line of submission, the case of EFF, Economic Freedom Fighters versus National Assembly, 2018, South African Constitutional Court. Which way for Kenya? The first petitioner has gone through what happened in terms of the process. It paints to us a very worrying state in terms of the health of the democracy that we have in this country called Kenya. This is a clawback in terms of the Constitution and the state of our democracy, culminating into the Constitution 2010 that was characterized by huge cost for the ordinary Kenyans. People shed blood, people were killed, and people died. We should not lose focus of that. And that state of affairs painted by the first petitioner leads me to pose this question to the court. Did we need specialized rules and procedures for this process of investigations and hearings to be established before the process commenced? Did we need specialized rules and procedures before the process of impeachment investigations and hearings commenced? That is a question, your lordships, your ladyship, this court must answer. And like my elder senior counsel, Elisha Ongoya, I'm relishing to read the answer to that question from this court. On our part, we respond in the affirmative. Yes, we must, and we needed to have specialized rules before the impeachment began, either in form of a specialized code, or it ought to have been mutually agreed between the parties. Parliament ought to have sat down with the Deputy President and agreed on the rules of procedure, or else we should have had a specialized code. For the following reasons. Number one, protection of constitutionalism and the rule of law. Pre-established rules ensure the impeachment follows constitutional norms rather than political convenience or sudden improvisation. The Speaker extends it to Saturday. Parliament says no. We will do as we wish. Error. Kosa kubwa. Secondly, prevents abuse of power and political witch hunts. Clear procedures make it harder to weaponize impeachment and partisan revenge for short-term political gain. Number three, guarantees of fairness and due process. the office holder facing impeachment deserves predictable procedures, notice of charges, a right to respond, and an impartial hearing. Number 4, enhances legitimacy and public confidence. When procedures exist beforehand, the public is more likely to trust the outcome as lawful and not pre-engineered. Public trust, public confidence. Next, it ensures institutional consistency. Preset rules prevent changing procedures mid-process to suit the circumstances or the person under investigation. We are giving you, was it 10 days? Then midstream, we are going to continue, irrespective of whether you are sick or not. Rule of law questions. Can we operate a serious constitutional interrogation such as an impeachment in that manner? No, we say. Promotes separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of parliament, courts, and other bodies. Number 7, provides clarity and efficiency. Investigations and hearings move faster, are more coherent when procedural uncertainty is removed. Number 8, protects minority and dissenting voices. Those that dissent, and for aught we know, perhaps we had dissenters, people who are willing to vote against the impeachment. We may never know because the rules lacked. Formal rules ensure minority members in legislative bodies can participate meaningfully and are not outshot by majorities. It creates objective evidentiary standards. We had objective evidentiary standards from the courts. If that was applied in Parliament, that we don't know. But if that was agreed to in terms of rules, we will know what we are facing in terms of what evidentiary standard are we going to abide with. Finally, it builds a stable constitutional precedent. A predictable framework helps future impeachment processes remain consistent, credible, and less destabilizing to governance. A stable constitutional precedent can only emerge where constitutional values are treated as binding rules rather than aspirational rhetoric. If foundational values of the Constitution are understood as enforceable obligations, they naturally demand structured, predictable procedures whenever the most serious constitutional powers, such as impeachment, are exercised. In this way, fidelity to constitutional values become the anchor for consistency, ensuring that future impeachment processes are guided by principle instead of political expediency, and that governance remains stable, credible, and firmly rooted in the rule of law. The reasons for a rule-based impeachment process. There are no rules. In terms of the constitutional values at play, this court is going to make a decision for expediency. This is not just any other decision. Constitutional values are not decorative. They are not mere suggestions on the walls. They are binding obligations. These are our pillar stones, and these values that we have in the Constitution, such as the rule of law, due process, constitutionalism, accountability, transparency, separation of powers, are a must. They are inextricable. So when impeachment procedures occur without procedural law, clear procedural law, Parliament is no longer implementing the Constitution. It is operating outside it. And I dare confidently, with all the strength from my ancestors from Nyahera in Kisumu, say this, that impeachment is not a political ritual. It is a constitutional trial. May I repeat this for members of the National Assembly? My senator from Kisumu is here. Impeachment is not a political ritual. It is a constitutional trial. So without procedure, the process becomes arbitrary, and this directly undermines constitutional supremacy. That is one. Number two, the rule of law requires procedure. Power cannot operate in a vacuum. The rule of law means that power must be exercised through known, predictable, and fair procedures. We are extending time for you till Saturday. No, we are continuing with the impeachment immediately, irrespective of whether you're present or not. That is rule by man, not rule of law. Failure to have procedural law in the context of this impeachment meant this, that we did not have clear, predictable rules of evidence. That is one. The burden of proof, if at all it existed, kept on being a moving target. There was no right of defense. It was never guaranteed in the first place. People wanted to finish with what they wanted to do and move on. There are no clarity in terms of timelines, fairness, or impartiality. This creates a dangerous precedent where decisions depend on political discretion, not law. The process becomes rule by numbers, not rule of law. And in constitutional theory, absence of procedure means absence of legality. May I repeat that? Absence of procedure means absence of legality. Number three, impeachment is a quasi-judicial process, not a political vote. That term quasi-judicial has been used a lot here. But what is exactly meant by quasi-judicial? In my other life, I'm a member of the academy, and I see two senior members of the academy here. They can confirm that, and may God bless them in advance. Professor Jenda, Professor Gido Muigai, senior members of the academy. Quasi-judicial power means this, that this is the power to determine disputes or making findings affecting the rights of individuals, similar to the way courts operate. What was at stake during the impeachment? A validly elected deputy president of the republic was going to be impeached. His rights personally and the rights of his many supporters, those who voted for him as part of a ticket, were going to be affected. The consequences are there in terms of the quasi-judicial power. The removal of a deputy president being a very serious constitutional action. It has consequences for the electoral will of millions of voters, stability of the executive, continuity of government. And because of this gravity, impeachment must meet quasi-judicial standards. Quasi-judicial standards, these are the principles of good governance. I don't want to go through the whole list, but again, members of the academy, Professor Don Oliver has reduced the principles of good governance into four. Very quickly, these are legality, procedural propriety, rationality, and proportionality. The Oliverian quadrant: legality, procedural propriety, rationality, proportionality. When this court retires, we pray that you are going to consider those four principles. This process, as has been brought out by the first petitioner, do they meet the tests of legality? Do they meet procedural propriety in whatever guise? Does it mean rationality? Again, Professor Jenda should be familiar with Wednesbury degree rationality That's a test.
Council address the court, not the academy.
Most obliged. Most obliged. Most obliged. If I veer into the academy, please forgive me. Most of the time, I veer towards the academy. Wednesbury rationality. Has the Wednesbury rationality test been met in terms of this particular impeachment process? Proportionality. Look at the allegation on, for example, what was said and what ought to have been referred to the NCIC, the National Cohesion Committee. Was that proportional? Does it meet the proportionality test? And on that very issue, Senior Counsel Paul Mwite submitted to it. There's the principle of subsidiarity that is captured under Section 15 and Section 26 of the NCIC Act. Parliament ought to have deferred to the authority of the NCIC on the allegations made against the Deputy President. NCIC ought to have made the primary decision on the gravity or lack thereof of what was said. So the assumption of Parliament without going to the NCIC is not only illegal and unconstitutional, it also offends the principle of subsidiarity. When Parliament conducted itself in the manner it conducted itself, Parliament acted as the Hobbesian Leviathan. It became the investigator, the prosecutor, the judge, and the jury. This violates Article 47, principles of fair administrative action, and judicial action, quasi-judicial action. Procedural fairness protects the people, not just the office holder. Impeachment is often framed as an accountability of one individual, but constitutionally, impeachment protects the voters who elected that office holder. If procedure is absent or conducted in the manner it was conducted in this case, the electorate's choice can be overturned by unregulated political processes. This weakens popular sovereignty, a core constitutional value. Thus, the real victim of procedural failure is democracy itself. Whereas it protects, there are protections for the individual, the real protected target is the core principle of popular sovereignty. 5, the absence of procedure invites a constitutional crisis. Why? Because without procedure, courts are forced to intervene, parliaments claim political privilege, the executive legitimacy becomes contested. We have a deputy president who did not come through the ballot. That's a legitimate question. Institutional conflict arises between the arms of government. And this leads to the usual talk, judicialization of politics, politicization of constitutional processes, public loss in institutions. A constitutional democracy cannot survive when removal of national executive and office holders lack legitimate legal guardrails. 6, separation of powers demands legal boundaries. Parliament has the power to impeach, but not without limits. Parliament becomes a judge in its own course without procedural law. Checks and balances collapse. Majority power replaces constitutional restraint. Remember, we are at state under constitutional restraint, not abundant political power. The way in which this impeachment process was conducted contradicts the idea that constitutional supremacy restrains political majority. That is something we will invite you to find. The rules of natural justice, there are 3. The right to be heard, freedom from bias, and those have been submitted to. Then there's the 3rd rule, the rule in R versus Sussex, Justices Ex parte McCarthy, 1924. And this rule, as articulated by Lord Justice Hewitt, simply says this, that justice must not only be done, but manifestly and undoubtedly it must be done. justice must not only be done, but manifestly and undoubtedly it must be seen to be done. In terms of this process of impeachment, the process has continued when the substantive subject of impeachment was in hospital. He did not have the opportunity to rebut or to respond to the charges. In terms of the third rule, the first two were submitted to. I focus on the third rule. R versus Sussex Justice Magistrates. Justice must not only be done, but must be seen to be done. Do we see justice to have been done in this context when somebody was sick in hospital and processes continue without him being present? It's a problem. Precedent danger. Today's deputy president, tomorrow's democracy. If impeachment can continue and happen in such a shambolic manner that it happened, future removals will be done and can be done more easily. The threshold for removing elected leaders becomes political convenience. My brother Ochiel gave us the history. I don't want to go through it. Political convenience brought us to where we are in terms of shielding the office of deputy president. Executive stability becomes fragile. This transforms impeachment from a constitutional safeguard into a political weapon. Is that what we want in terms of this court? In terms of the jurisdiction of this court, I have completed with the rules of procedure. I want to go to the jurisdiction of this court. The High Court has 4 jurisdictional capacities under Article 165. The High Court has original jurisdiction, appellate jurisdiction, supervisory jurisdiction, and writ jurisdiction under Article 165. At play, particularly with regards to the matters before this honorable court, are the supervisory jurisdiction and the writ jurisdiction of this court. The supervisory jurisdiction becomes particularly important under Article 165(6) when supervising quasi-jurisdictional capacity of various arms of government. And this is where the court will invoke its judicial review power or judicial review authority. What is judicial review? Judicial review has 2 limbs to it. Judicial review is the primary judicial function to preserve legal order by confining the political branches to their proper limits of power under the Constitution. That's the first limb. The second limb is protection of private individuals by preserving or preventing illegal encroachment on the rights of these individuals. Those are the 2 capacities of judicial review. And when the High Court, under Article 165 of this Constitution, stands as the primary guardian and interpreter of the Constitution and its values, the court exercises broad authoritative jurisdiction, including supervisory and constitutional oversight over the National Assembly. So that the National Assembly will not be had to say that this is a political question beyond the reach of the court. This court, the breadth of its constitutional and supervisory jurisdiction is a capacity granted by the Constitution, and it's not an intrusion into the domain of the legislature, and is a necessary feature of constitutional design. I hear telepathically, and I can almost predict that you will hear this from the respondents, that Parliament has its right to formulate its own procedures. If the courts will be inclined to find it that way, we have provided to you a case, Maneka Gandhi versus Union of India, 1978. And it presents to this court a test. The Supreme Court of India, interpreting Article 21 of the Indian Constitution, speaks of due process in this manner. It says, number one, that procedure as a capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment and you're satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with the process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say, the stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democratic institutions, and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark old ages. I submit. My brother Sakimpa joins in next.
Thank you.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitions. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with two issues, because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle two issues, the first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate, and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the fourth petitioner, that is Honorable David Munyi Madenge, where, Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed. And that is what he has deponed in his affidavit, to the effect that he did not participate at all, because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having given their views in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mwongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient, and therefore ordered for a second phase of public participation. So, Your Lordship, what the National Assembly did, instead of going back and preparing for a proper public participation as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same day, that is on 5th of October 2024, telling the public that we have extended the public participation. So, Your Lordship, that notice was not enough, and even from the affidavits that was sworn by the 5th, 6th, 7th, and 8th petitioners, Your Lordship, they do confirm that they came to realize that the extension was given after, in fact, on the next day. So, in short, Your Lordship, because I don't want to repeat what my colleagues have already said, it is our humble submission that this court return a finding that indeed the notice was not sufficient for a meaningful and qualitative public participation. So, Your Lordship, on the other issue of quantitative aspect, my learned senior, Mr. Tom Masharia, had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025, where, of course, the court, in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And Your Lordship, we have it in page 1 of the affidavit that was sworn by Honorable David Madenge. It is page 1. So, and the document is a presidential memorandum of nomination by His Excellency the President William Ruto to the National Assembly. And it says that whereas pursuant to Article 150 of the Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointments Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the Presidential Memorandum of Nomination is substantially in compliance with the provision of this act, except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of did comply substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of constitutional and statutory appointments and for connected purposes. So, Your Lordship, from the memorandum by the President of nomination, it is clear that this is a constitutional appointment, because he actually says that pursuant to the provisions of Article 150, a vacancy has arisen in the office of the Deputy President. So, in essence, Your Lordship and my lady, this is a constitutional vacancy and a constitutional appointment that was subject to the provisions of the Public Appointments Parliamentary Approval Act. And Section 3 of that Act says that the exercise of powers of appointment. So an appointment under this Constitution, that is Section 3, an appointment under this Constitution or any other law for which approval of Parliament is required shall not be made unless the appointment is approved or deemed to have been approved by Parliament in accordance with this Act. So, Your Lordship, it is clear that the appointing authority in this case was the President. So after appointing Professor Kithure Kindiki as a nominee for the position of the Deputy President, it was subject to the application of this Act. And as I said, Your Lordship, the memo complied completely in all aspects with this Act, save for public participation. So, and Section 5 also provided for notification of nomination. And it says that an appointing authority shall, upon nominating a person for appointment to which this Act applies, shall notify the relevant House of Parliament. So it is through this Presidential Memorandum of Nomination that Parliament was notified of this appointment of Professor Kindiki. And it further says that a notification of appointment shall be accompanied by information concerning the nominee having regard to the issues mentioned under Section 7. So, Your Lordship, I am sure that you will have an opportunity when you retire to examine this presidential memorandum. And in fact, it does highlight that the President says that for reasons whereof I have enclosed the following documents, and which Senior Counsel Paul Mwite said that it was done in an ungodly speed. So, Your Lordship, I want to reiterate that the essence of this Act was provided by Parliament so that it provides safeguards, especially on the issue of public participation, where the citizens will be given an opportunity for them to give views on the new nominee. And that is the procedure even in terms of the appointment of cabinet secretaries and all the appointments that are made under the Constitution. And Section 6, which is the most important part, it says that the committee, Section 6(4), approval hearing. So the committee shall notify the public of the time and place for holding an approval hearing at least 7 days prior to the hearing. So, Your Lordship, 7 days prior to the date of the hearing. Your Lordship, of course, from what we've heard is that the impeachment was done on the 17th of October, and on the next day, that is when the President forwarded this memorandum of appointment. So, Your Lordship, from that moment, the law requires that before the approval was done, the public had to have been given a notice of at least 7 days. So, Your Lordship, and the President further says, in forwarding this nomination, that, and he quotes Article 149 of the Constitution, which says that within 14 days after a vacancy in the office of the President arises. So, Your Lordship, within 14 days, of course, this was done within a few hours. It was, the impeachment was done at night, and in the morning, the President did this act. So the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. So, Your Lordship, under Article 149, the Constitution gave 60 days for Parliament to consider the appointment of the new nominee. And the reasoning, Your Lordship, is there are these documentations that have been given by the President forwarding the nominee. Parliament was under an obligation to consider those documents within a period of 60 days. Your Lordship, by midday on 18th of October, Parliament had already voted on the issue of appointment of Professor Kindiki in complete disregard of Section 6(4) that required the public was to be given at least 7 days so that they can give their issues in terms of the suitability of the Deputy President nominee. Your Lordship, but obviously that was not done. And Your Lordship, I'll also now refer to the response that the National Assembly, in their submissions, they have filed, or rather they have given a ridiculous response to these submissions that we made. And under paragraph 361 of their submissions, they say that, in fact, this was a sui generis, it was a sui generis procedure, to the effect that it was not an approval, but a vote by the National Assembly. Your Lordship, assuming even we take the argument that they say that in fact it was a vote and not an approval hearing, Your Lordship, then the provisions of Article 118 of the Constitution will then apply, because they will still need to conduct public participation as required under Article 118. And Article 118 provides that public access and participation. So it says that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So, Your Lordship, even if they escape the provisions of Section 6(4) of this Act, of the Public Appointments Parliamentary Approval Act, then they cannot circumvent the provisions of Article 118, which requires that Parliament must still, in all its businesses, involve the people. And Your Lordship, there is an authority that I want to rely on, and that is Legal Advice Center and two others. It is in our case, in a bundle of authorities, versus the County Government of Mombasa and 4 others. It's a 2018 decision. And Your Lordship, I just want to quote in verbatim a very small part where the court said that the purpose of permitting public participation in the lawmaking process is to afford the public an opportunity to influence the decision of the lawmakers. So, Your Lordship, assuming that we were to take the proposal that they said that this was a vote that ought to have been taken by the National Assembly, then under Article 118, they must have sought public participation before they made the vote to approve the Deputy President nominee. And Your Lordship, they further give a fallacious explanation and say that actually it is equal to the election of the Speaker and Deputy Speaker and members of the regional parliament, that is IALA. So, Your Lordship, that is not true. In this case, this nominee is directly appointed by the President, and there is a memorandum of presidential appointment. In the case of a Speaker and members of the East African Legislative Assembly, they are directly elected by Parliament, or rather in whichever house that is applicable. So there is no nomination that happens by any authority in terms of before the Speaker is elected. They are directly elected by the members of Parliament. So, Your Lordship, the last issue that I'm going to discuss as I conclude is on the issue of whether the Senate violated Article 145 in terms of taking the plenary route. Your Lordship, our submission is that it was not open in law for the Senate to take the approach of the plenary. And my learned senior Ochiel Dudley had already discussed Article 145.3. So, Your Lordship, I will not belabor on that point, other than to submit that under that provision, that is Article 145.3, where it says that the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President, and the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. So, Your Lordship, even if we were to apply all the statutory, or rather all the interpretations, rules of interpretations of the Constitution, all of them will point to the position that the appropriate route was the special committee. And Your Lordship, there is, the first rule is the literal, of course, interpretation of this provision. It is clear that from the reading of that provision, there is nowhere in which the framers of the Constitution provided that a plenary session can be held to investigate into the conduct of the Deputy President. And in fact, Your Lordship, from Article 145, it is clear that the Constitution was very clear in terms of the impeachment of the President, because it does apply to the President, and of the Deputy President. It went further to actually provide what needs to happen. And it is a constitutional buffer that was put there to ensure that whoever is undergoing the process of impeachment will get the benefit of the law. And I will shortly be reading the provisions of Article 27 of the Constitution, where it actually provides for equal benefit of the law. And maybe I can just quickly, as I finalize, read section 27(1), which provides that every person is equal before the law and has the benefit and has the right to equal protection and equal benefit of the law. So, Your Lordship, under Article 27, there is a benefit that has been, under Article 145(3), there is a benefit that has been put there by the Constitution, and which the second Deputy President was entitled to benefit from this provision of the Constitution in terms of having a special committee to investigate into the allegations that were leveled against him. So, Your Lordship, and if we look at actually that provision again, if we were to take the position that actually a plenary is also a route that is provided here, it will actually amount to a discriminatory act in the following sense, my Lord and my Lady, that it means that the Senate will be deciding. There is no criteria as to when the special committee will be applied by the Senate and when a plenary will be applied by the Senate. And Your Lordship, what that means is that it will depend on whether the Senate actually, you are in good books either with the Senate or whoever who is in charge of those impeachment. Because there is no procedure that actually provides that under these circumstances, a special committee must be undertaken, and under these special circumstances, then the plenary can be undertaken. It is left to the Senate to determine at whichever time they are going to use whichever mode. And Your Lordship, that has been demonstrated even in the impeachment of governors, where you find that some governors are subjected to the plenary, others are subjected to the special committee without any justification why this was used over that. And therefore, the purposive interpretation and holistic interpretation of this article will yield a conclusion that at all times when it comes to the impeachment of the president or the deputy president, a special committee must be constituted by the Senate for purposes of hearing, investigating, first of all, whether the charges have been substantiated before a recommendation is made to the Senate. And finally, the other rule that I want to rely on is on the Latin maxim that expressio unis est exclusio alteras. So, Your Lordship, that provision basically means that what has been expressly provided under the Constitution, any other thing is excluded. Your Lordship, the framers of the Constitution, if they wanted to have both modes available, then, Your Lordship, there was nothing difficult in them saying that either they investigate by the committee or by plenary. They expressly excluded the provision of a plenary, because what the Constitution wanted is a process where the president or the deputy president is given an opportunity to, first of all, for the Senate to first of all investigate by the committee, and finally that the matter be deliberated in the Senate. So, Your Lordship, in light of those brief submissions, we do pray that this Honorable Court finds that the impeachment of the second deputy president was unconstitutional, invalid, and null and void. Those are my humble submissions.
Can you in just 1 second tell me the remedies we're seeking in this petition?
Yes, Your Lordship. In our petition, we have several prayers that we've sought, and the first prayer is a declaration that the appointment of Professor Kithure Kindiki as the Deputy President of the Republic of Kenya was invalid, null and void for the reasons that we've given in terms of there was no public participation. Your Lordship, another prayer that we did seek is a declaration that the National Assembly and the Senate were under an obligation to undertake separate public participation in respect to the impeachment of the second deputy president. Further, Your Lordship, another prayer that we sought for a declaration that the public participation that was conducted by the National Assembly on 4th October and 5th of October was not proper, effective, and meaningful within the provisions of Article 10 and 118 of the Constitution. And finally, that the impeachment process of the first interested party, being the second deputy president, was invalid, null and void. Those are the submissions. And Your Lordship, of course, cost of this petition.
Thank you very much.
And we do support the position that was taken by the first petitioner. Most obliged, my Lord.
Thank you. Mr. Omoke.
Your Lordship, I would like to present my petition on a fresh day. So I'll let Ms. She can go ahead.
Are you revising the directions which we made without application?
No, Your Lordship. I would like, for the second petition, she can proceed.
So why do you want a fresh day?
No, I can still carry on today.
Yes, my name is Teresia Wanjiru Kimoto Makazi from Tess Kimoto and Company Advocates Kerugoya. I'm for the second petitioner. So my petition is the one dated okay, thank you. It's the one dated 25th September 2024. And in that petition, we are seeking several orders. And in those orders that we are seeking, one, we are seeking that the then Honorable Rigathi Gachagua, there be a declaration that the constitutional rights of the applicant, who is the petitioner, provided for under Article 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. And that the first respondent, who by then was the current Deputy President, be ordered to issue an apology to the NIS members and staff due to the utterances and speech made on the 26th June 2024. Cost of the petition and any other relief the court may deem fit. Of course, we wish to say that our petition has not been opposed by anybody. Let me finish. And we rely, of course, on the facts in support of the petition and our supporting affidavit as it is. We also wish to say that the reason why we had done an application to stop the impeachment proceedings is because...
I don't like doing this. But clearly, Ms. Kimotho's petition is overtaken by events. The petition sought an apology by the second Deputy President to the NIS. That did not happen. The impeachment occurred. A vote was taken on that question, and it is the subject of the first petition argued by Senior Counsel Paul Mwite. So Ms. Kimotho should sit down. Thank you.
No. We are opposed to that because that's not true. The apology we were seeking is an apology from the Deputy President, whether he's sitting or not sitting. So we are very much in place. And again, we also wish to as I proceed before I was interrupted by my senior, I wish to say that we are also in support of, we are against the process of impeachment. And we are going to say why, if I'm allowed to say. The reason why we are in support of, why we are against, the impeachment process is that the grounds that we relied on in our petition are the same grounds that were being litigated by the Senate. The judge, when we went to, our petition was first, E013. When we went to the High Court at Kerugoya, we raised these issues. The Senate had not yet started the process, the impeachment process. And so we felt that if we were hard fast, then this whole issue would have taken a different turn. Because once a case is pending in court, once the issues that are being raised are the same issues being raised in the Senate, then we ought to have been heard first. And that's what we have been raising from the application that we did, and even in this situation when we are arguing our petition. We again say that if you look at the entire process, any person who goes to court must be heard. That's an Article 50, fair hearing. Then if the same issues that are being raised here are raised there, then of course there's an issue. It shows the senator, because we served the Senate, and the Speaker clearly acknowledged that there's a petition going on in Kerugoya, but they ignored. This can only show their minds, they had made up their minds. And that's why now we are in support of the petitioners against the entire impeachment process. And this point is very, very important. Again, if you look at when we were consolidated, there came the issues again that are being raised here. Public participation, which on our part, we are supporting. We are saying the public participation that was done was not done well. His Excellency Rigathi Gachagua, His Excellency the President of Kenya, William Ruto, are people who are voted by Kenyans as a duo, not individually. So now when His Excellency, one duo, one person, one part of that duo is subjected to impeachment without the same process that was used to bring them to power, then that issue violates the Constitution. And why are we saying this? If you look at how they were elected, polling stations were everywhere. Each constituency, each polling stations in the wards, people were allowed to vote. So now when it comes to public participation, in where now we want to remove one duo, why are Kenyans not being told, come, let's get your views on the removal of one duo that we elected? How can we be told we don't have a right to be here right now? We do have a right, because if Kenyans did not participate equally as they did participate during the elections campaigns, then the process, any public participation that is said was done here was a sham. The second issue, why we are in support of these petitioners. Again, you can see how, and these are allegations that are in public domain. In fact, in our petition, we are accusing the Attorney General of these issues. Everybody kept on saying the MPs were given 500,000. The senators were given 1 million. These are allegations in the public domain. Can we say this process was fair when people out there are claiming there is bribery? We have seen several talk shows, people continuing saying these issues. So we are objecting to that process that was done. The other point that we wish to say is, okay, again, that was repeated, but I can emphasize, on the day of the Senate, we see the then Deputy President, Rigathi Gachagua, falling sick. We have served, there's our order, standing there, the Speaker of the Senate acknowledging that yes, we've been served with an order. Then suddenly the Deputy President becomes sick. And then what happens? The Senate does not care. They give a few hours, a few days, and then say, we will proceed, whether he appears before us or not. We go back to Article 50, fair hearing. Fair hearing means, however that person is, he must be allowed to give us his side of story. Kenyans were waiting. Kenyans were watching the TV. They wanted to hear His Excellency Rigathi Gachagua tell us, we voted for him. We want to know what happened. What happened, yet we voted a duo. So this chance we were not given. What we saw was in Senate, people come in and the lawyers speak and other allegations, paperwork. So we Kenyans would have expected to hear his side of story. So in that, we say he was not given a fair hearing, and therefore that impeachment process was not conducted the correct way. Yes, I think my points, those are my few points. They are very fiery, so I don't want to keep.
Of course they are.
Yeah, I don't want to spoil anything. That's all for me.
Thank you. They are fiery. Thank you very much.
Okay.
Yes, thank you.
My Lord, Tess forgot to say that Kerugoya is in Kirinyaga.
Oh, yes.
Correct.
Can we see how many people are yet to submit? How many?
My Lord, there's the third petitioner.
Mr. Kibe. Where is Mr. Kibe? Can I see how many are yet to submit? So we'll proceed until 6.
Did your lordship give an indication of up to what time you will be sitting?
6. 6.
Today?
Yes. You want us to amend it?
No, I just want,
Yes.
I was just asking for clarity on up to what time today you will be sitting.
You know, these people, I don't know where the councils have arrived from, because when we were taking quorum, they were not this large. Some people have just appeared. Some of the councils have just appeared now, because you spoke about 8 people. 8 councils, yes. And then after that, we have had now, I see quite a number of councils are here. I don't know, maybe.
Probably a misunderstanding. The 8 council I stated
Yes.
are the 8 council appearing for the first petition. There are many other petitioners, and these council are for those other petitioners.
Yes.
But looking at the number, it's a matter entirely in your lordship's
So we
discretion.
can do up to 6. Then after that, we can make further directions.
Okay.
Yes.
Thank you, my lord.
My Lord,
My Lord, just so that I may get some clarity, the 2 of us going, 6 o'clock, that's in 30 minutes. It would be better if we took a proposal to get directions from the court, because I would definitely need more time. Unless maybe I might be lucky that there's one of us who can do it in 30 minutes to make 6. Okay, he's willing to do 30 minutes.
Okay.
Your Lordship, once again, my name is Murara Omoke. I am the 43rd petitioner. I filed a petition on my own behalf, and I was deeply offended by the manner in which the impeachment process was being conducted. And therefore, in compliance with the Constitution, I came before this court to defend it. It was not about my political alignment at the time. but about the Constitution, and that's why I'm here today. My petition is E027 of 2024. I have a supporting affidavit sworn on 9th of October 2024.
E0.
Sorry?
E047.
E027 of 2024. The same date. On the same date I saw the affidavit, 7th of October 2024. I filed very brief submissions dated 1st of April 2026, in which I sought to address two issues, as I do not wish to repeat what the first petition has already submitted on, but I fully support the submissions presented by the counsels for the first petitioner. And I will proceed to make a few additions. On the issue of public participation, I personally attended the public participation exercise at Kiambu Social Hall. I'm a resident of Kiambu County, although I'm born in Kisii. I attended, and I can confirm that the form that was provided to the participants only summarized the allegations against His Excellency Rigathi Gachagua without provision of any particulars or any evidence in support. So I can confirm as a participant, and there is no response in opposition to my petition to challenge that position. There was no evidence in support of the various grounds of impeachment as presented to the public. Secondly, there were no attachments of His Excellency Rigathi Gachagua's response, which at the time had already been filed before the National Assembly. It was never provided to the participants. And as Aleron stated, the public was only being asked to give an opinion of yes or no, and only a very small provision at the bottom of the form to say any other thing. I also would like to indicate that the manner in which, rather the form, the language was only in English. And as you know, in this country, we have two official languages, English and Kiswahili. Earlier on in Swanya's submissions, he did talk about the BBI case. Actually, in that case, I prosecuted that point on providing different languages when it comes to public participation, especially on an issue that is so important as this impeachment. It was only done in English. There's no explanation why it was not done. They could have taken time, but because there was the hastiness with which this process was being carried out, of course, there was no attempt to provide for any other language. In my petition, I gave a background to the impeachment process, and I did find fault with the lack of partiality on the part of the Speaker of the National Assembly and the Deputy, and the remarks they made prior to the impeachment process. Starting with the Deputy Speaker, she did say, mimi mwenyewe nitampeleka nyumbani, in a public rally. Around the same time, the Speaker for the National Assembly even quoted a verse from the Bible about getting rid of something that is considered to be inappropriate, in reference to the Deputy President, even before the impeachment motion was presented before the National Assembly. And this, as we said, while they do not vote in an impeachment process, they preside. So it is extremely important that the two individuals who have the mandate of presiding over the impeachment process ought to act with impartiality, and they have to have no bias. And I would have to say that the two of them totally failed, and that vitiates, in my opinion, in my own submission, that vitiates the entire process. They should have refrained. They could have been more restrained in their remarks, even if they that's what they believed. But they totally rendered the process unacceptable. I'll come to another issue. In the manner in which the grounds of impeachment were debated, and you look at the Hansard for the National Assembly, I'll make reference. I've seen multiple copies, but there's a copy before the court, I believe. I would ask you to look at page 18.
Which dated?
The Hansard is in reference to the impeachment proceedings. I believe it should be before. Without it before this court would mean that I'm not able to point out the specific date, but it should be before the court.
We had two.
The one for the National Assembly. I'm making reference to the one in the National Assembly. It's 5th of October, 2024. Sorry, Your Lordship, 8th of October, 2024. In that particular Hansard, at page 18, I picked the remarks that were made by the Member of Parliament for Suba South, Karoli Omondi. At page 24, I picked remarks that were made, I believe those were made by Honorable Catherine Omanyo. And also, I'll take the two of them. So they went ahead and introduced other issues. Also, I forgot to mention the Member of Parliament for Mavoko, Patrick Macau. Actually, that is at page 24. Then at page 42 and 43, you will find those of Catherine Omanyo. I will not go into what they said, but I would ask the court to look at some of the issues they said, which to me were personal issues they had with the Deputy President, or some long-held grudges, which they used as their reasons for endorsing the advancement of the impeachment to the Senate. This being an impeachment trial, which, as we said, in the standard set in the Wambora case, which requires a very high standard, and the Constitution, which also talks about grossness and seriousness of the misconduct and the violation, you cannot introduce any other ground, even if that's what is your reason. You have to debate, you have to vote on the impeachment on the basis of the grounds that have been stated in the motion. So that is another failure, which on that basis I would ask the court to find that the impeachment failed to meet the standard, the constitutional standard. It has to be the constitutional standard and threshold, and therefore it ought to be declared null and void. Your Lordship, I would now move to present on the issue of lack of legal mechanisms, or rather legislation, to operationalize Article 150, in this case, of course, which incorporates the other articles on impeachment. Again, on this issue, I did make a presentation in the BBI case on the lack of legislation. In that particular case, the issue was lack of legislation for collection of signatures. And that was an important issue in the BBI case. And the court agreed, and I would ask this court to make that finding, which is extremely important, that this kind of a process, being so important, must have legislation. And I would like to state why it is important. For instance, when you look at the provisions touching on the election of a president and a deputy president, it's very clearly provided on the judicial review available to any party who is dissatisfied with the process. It's elaborate. It has to be that you come before the court, you raise your issues, the court makes a decision. Thereafter, then whoever is elected is sworn into office. So the Constitution, in a way, has actually enforced some conservative relief. However, that is not provided on the issue of impeachment, and therefore, just as important as the process of occupation of that office, so should be the process of exiting that office. And that, therefore, would require legislation to address that issue. Before this court, we argued on the issue of conservatory orders. Your Lordship, it leaves us in a difficult position. If this court was to find that this impeachment process was unconstitutional. How do we cure the fact that His Excellency Rigathi Gachagua was hounded out of office, replaced, and now he's left without a solution? Because if we say, for instance, that if we were to order him back to the office, the kind of situation we face is difficult. And that is why it's important to have legislation to provide for room for judicial intervention before the swearing in of the new occupant of an office, if the court was to ever confirm the impeachment process. It also would also aid the person, the incoming, not to come in under the cloud of illegitimacy. Because as we are here today, we have issues have been raised by my colleagues about the fact that the replacement came into office hurriedly without any safeguards. You know, there was no vetting. Because it, being an appointee, then it reduced him to that level of requiring vetting. While for an elected deputy president, the vetting is with the people. They vet and they vote. So I would say that this is an issue that leaves us in a, which actually paints a cloud of doubt on the efficacy of fair hearing in the Constitution. And my hope is that the judiciary would acknowledge that the fact that we did not have conservatory orders in place was a problem. And I would explain why. In the Constitution, there is a line of succession provided that if the president is not there, the deputy president will come into office, would act in that period of vacancy. If the two of them are absent, there is a Speaker of the National Assembly. And the fact that in the ruling on conservatory orders, we did recognize the significance of this office. Therefore, it will become so important if we had legislation to even provide for such situations. What should happen? In my petition, I have only asked for two reliefs: a finding on the unconstitutionality of the process, and on the issue and the question of a lack of legislation, which as I submit before this court and ask this court to align with your colleagues in the BBI judgment, that lack can render this kind of a process flawed. I so submit to your lordships and my lady.
Thank you.
My lords and my ladies, I see it is around 5:50. I'd requested court for 20 minutes, but based on what has been submitted, I'll only take 10 minutes because I wish not to repeat and regurgitate what my seniors and the petitioners who have come before me have already told this court. Your Honor,
I don't think we'll be able to hear you now because there's another petition we are mentioning and time is well spent. Just give us a few minutes, we'll give you directions.
Much obliged.